May it please the court, as well as ouslander attorney pro se. I understood your Honor's instructions that you wanted essentially an argument that clarifies the issues, their essence. And I believe I can do that for you. I think there are three main areas the court should focus on in this case. One is statutory interpretation of the non-fulfillable right. I understand from your questioning that at one point you assume there is a right. I won't assume that that is in fact correct. I'd like to prove it to you. But in essence, the state has spent a great deal of time in its brief arguing that the words of the statute don't mean what they say plainly and clearly. I believe that this case essentially starts and ends with the phrase benefits program. Surprisingly, in the state's brief, they indicated at one point that whatever the nature of the rights the statute grants, they want to make a point, as if the statute had not been interpreted by this court previously in NGA versus state. It was. And Judge Perillo found, writing to the court, that there was in fact a right to receive pension benefits. At that time, he indicated there was no right to have funding for those benefits.
That language is different.
No, I don't believe it was. I think it was a subsidiary holding. And because one of the arguments in that case, as I understood it, was that because you have this right to your pension, there's a concomitant right to fund it. Otherwise, it's meaningless. It's a right without a remedy. But more importantly, Your Honors, even if it was dicta, I'm certain that Mr. Lukey would concede that during that case, the state conceded, as Judge Perillo in his opinion, that there were in fact enforceable contractual rights. The state's brief now is 180 degrees in the opposite direction. They're now saying that the phrase benefits program does not include COLAs, cost of living adjustments. And as I've tried to make clear to the court, not only do the rules of statutory construction indicate to this court that statutes regarding pension benefits are to be liberally construed in favor of pensioners, but it was a very expansive phrase they used. In fact, it's so expansive that the only exception listed in the statute is post-retirement health care benefits. And I argue to this court that persuasively that means when they use the phrase that the benefits program shall not be reduced, they meant all pension benefits, deferred retirement benefits, service retirement benefits, special retirement benefits, ordinary disability benefits, accidental disability benefits. None of those words or phrases appear in the statute, Your Honor. I can't imagine that Mr. Lukey would then argue that the phrase benefits program doesn't apply to all those various forms of pension benefits. Once this court makes a determination that the non-fulfillable right includes cost of living adjustments, and I suggest strongly it does, because we have other appellate court decisions indicating that COLAs are part and parcel of a pension, they just adjust the pension so it doesn't erode due to inflation. It is part and parcel of the base pension benefit. The state argues in its brief that it only applies to the base pension benefit. Those three words don't appear in the statute. The only description of the benefits covered by the non-forfeitable right are that the benefits program shall not be reduced.
Let me just interrupt you.
Yes,
The purpose of the statute, the 1997 statute, was to make sure that the state was complying with the Internal Revenue Code. That's in the legislative history. I didn't see a whole lot of anything in the briefs about the Internal Revenue Code. Don't we have to look at that to see what the 1997 statute was trying to get at in order to figure out what it meant?
I'm not sure that that edition in 1997 about the non-fulfillable right was strictly because of Internal Revenue Service regulations or federal tax law. Every time that the pension laws have been adjusted, including in that time, you are correct, but even in the 2010 law and this 2011 challenge, they've always had to update our state law so it's in compliance with federal statutory law regarding pensions, so it remains a qualified pension plan. My understanding, Your Honor, is that Governor Christie Whitman at the time and the legislature provided a non-forfeitable right that is a contractual right to pensioners to receive their benefits. They weren't obligated to. There are many states where that's not the case. It might be a property interest. Mr. Lukey had submitted a 2611D letter regarding New Mexico. They don't have contractual protections for their pensioners. they have property rights. So they have some rights, but they don't rise to the level of contractual rights. In 1997, the state of New Jersey, for the first time in its history, and I use that language because that was from the state's brief at the time in the original NGA versus state case, provided a contractual right for pensioners to receive their benefits, and the benefits program wouldn't be reduced. I don't believe that right was placed there in compliance with federal law, although part of that original law did have adjustments to bring into compliance with the federal tax code. But that's also been the same with the 2010 amendments and the 2011 amendments that's the subject of this appeal. So I don't think it's required, but the state provided it. And in fact, in this new law, Your Honor, in 2011, one of the things they did, allegedly for benefits reform, was the non-forfeitable right has been repealed for new employees as of the effective date of the law, June 28, 2011. If it were, as Your Honor suggested, a federal requirement, the state could not have repealed the non-forfeitable right going forward. So I don't believe it was a connection, but there certainly were adjustments made to the law to bring it into compliance with federal tax law. The point I'd like to make, Your Honor, is that the statutory interpretation that should have been done by Judge Hurd was not, and that this court should be clearly convinced, based on the briefs you've seen from the appellants, including myself, that statutory interpretation, which this court does on a regular basis, what did the legislature mean when it wrote these words? You can safely believe, based on the statute, the words they used, and the rules of statutory construction this court abides by, that when they use the phrase non-forfeitable right means that the benefits program shall not be reduced, they meant all pension benefits, the sole exception in that universe being health care retirement benefits. That's critical. If Judge Hurd had actually looked at the statute and interpreted, came to the conclusion that cost of living adjustments are not part of the benefits program, that would have ended this case. There's no need to stampede for the Constitution and talk about the debt limitation and appropriation clauses. You don't have to talk about federal income tax law regulations. He could have just said, no, I read the phrase benefits program means base pension benefit. And that would have been the end of this case, strictly on statutory interpretation. I strongly urge this court that's not the case, because we have rules governing how one reads a statute. Remember, the non-forfeitable right was defined as the right to receive, or I should say that the benefits program shall not be reduced. Ordinarily, statutes don't define definitions. They could. They could have a definitional section and say the phrase benefits program shall mean, and then describe it even more particularly. They did not. So we're left with the rule of statutory construction that says to give words their ordinary and well-understood meanings, unless the legislature declares otherwise. We're back to what I initially started with. What does the phrase benefits, the plural, program mean?
I think we understand this already. Do you have another argument?
I do, Your Honors. Once one overcomes that initial statutory interpretation, that clearly is all part of the benefits program, there are two alternative legal theories that I urge the court to consider that would secure the payments of COLAs from the pension funds, not the state treasury, not the acquisition of debt. I strongly urge this court to see through what the state has argued. Essentially, it's an argument that's a straw man.
Your argument not
Yes, Your Honor.
preempt you, but as I understand it, your argument is they don't have to appropriate anything because the money is already in the trust fund. And
It
you're
is.
just asking that it be paid out.
But to those people who retired before the law took effect, and the reason I say that, Your Honor, is that there are different classes of people. I'm here to represent my own interests, just as Mr. Grossman is here to represent the interests of his clients. But people who retired before this law took effect are in an entirely different position than those people who retired after or current or active employees in the system. The reason I note that is twofold. One, I'm going to jump ahead to my other independent legal basis. There are many equitable principles that support retirees who retired before the law took effect to receive their cost of living adjustments. The state's brief essentially says that equitable estoppel and other equitable principles don't ordinarily run against the state. That's not entirely true. The case that I believe Mr. Grossman was trying to recollect was the Chiarello case, in which that case, according to the appellate division here in the panel, indicated that ordinarily when you retire, the laws and benefits in effect at the time that your retirement application is granted control. That was an individual who retired prior to other reform legislation taking effect. His retirement papers were held up by the Division of Pension and Benefits because they knew about the incoming law that had just been signed. He officially didn't retire or have the Board of Trustees act on his retirement application until after the law actually took effect, that is the effective date. Although about 4 months prior to the law being passed and signed into law by the governor, he had in fact applied for retirement. Because the delay was caused by the Division of Pension and Benefits and not the pensioner, that court held that fundamental fairness, another equitable principle, that people be given fair notice of a change in the law ahead of time so they could change their behavior or conduct accordingly, prevented the state from using the new law, even though technically his retirement papers weren't officially granted until after it took effect. So essentially they have stopped the state from enacting or using that law, I should say, against that pensioner. In addition, Your Honor, there's the principles of equitable estoppel, as I've just mentioned, and retroactivity. Retirees who've left before the law took effect, not retired after, have those independent legal bases to rely on besides the contract clauses, which I will address if Your Honor wishes me to. But one has to look at what Mr. Grossman had argued earlier. They're all equitable arguments. Prior to this law taking effect, it was introduced June 16, 2011, passed and signed by Governor Christie June 28, a span of almost 2 weeks. People who retired 5 months before the law took effect, a year, 5 years, 10 years, were on absolutely no notice that their COLAs would be interrupted, suspended, or for all practical purposes, terminated. They retired. They left the system. They quit their jobs. They may have found other jobs. They made plans in reliance upon them. There's nothing they can do to fix that. It is inherently unfair. That's what equitable principles are all about. It's simply not fair to change the rules, not only in the middle of the game, but as far as people who retired before the law took effect, they didn't just change the rules in the middle of the game. They changed the score after the game ended.
Okay, I think we understand it.
Very well, Your Honor. I'm going to address them in the contract clause arguments. At one point, hypothetically, you said if the court would have agreed that the benefits program includes COLAs, and that there is in fact an established contract, and that the impairment of it is substantial under both federal and state law. The question I believed Your Honor asked, or I understood it to be, was what about the impairment analysis? Does the state have a really, really good reason that it can break these contracts? And I submit to Your Honors, no, and you can make that decision on the record before this court. You don't have to send it back. I've outlined in my brief at length, but I do think it bears mentioning here. The state has a very long, troubled history in not making its annual upfront payments to the pension fund. Part of this record law was stipulated to by the state. Year after year after year, they failed to make their payments. And it got so bad, Your Honor, that ultimately they had to change the law, specifically the very law that Mr. Luby will soon be defending before you. In the first case, NGEA versus state, the primary holding, as I understand it, is that there was no constitutional right to fund it. That case.
We've heard arguments, but I think we're starting to get a little.
Well, I was trying to explain, Your Honor, how that lack of funding doesn't, or should not cause this court to say, there's really an impairment analysis here. We don't have sufficient facts to make that determination. In that very same case, Your Honor, which was decided in 2010, almost a little over 3 years ago, both the state's witnesses, and I believe it may have been Mr. Nowak's clients, their expert witnesses testified that the pension funds were solvent for 30 years. And Judge Perillo and that panel of the appellate division relied on that. In fact, it cited it then. One of the reasons Judge Perillo said there was no impairment of the union's benefits was because it was solvent for 30 years. Now Mr. Lukey appears before this court and says that the pension system is on the brink of bankruptcy. It went from solvency 3 years ago for 30 years to the brink of insolvency. And I believe, Your Honor, that's simply not the case. But more importantly, Your Honor, when we talk about the pension funds, as Your Honor alluded to earlier regarding federal tax law, the monies that I and other retirees seek to pay for their COLAs comes from the pension funds, their trust funds. Whatever monies are there have already been not only earned by the retirees, but the COLAs have already been funded. One of the things that you've seen, and I know that Mr. Lukey is certainly going to make a note of this to argue to you, is that somehow the fact that contributions by retirees doesn't go to funding their COLA. That's not true. Every time an employee makes a contribution, the actuary computes two things: the base pension benefit and the amount needed for a COLA, based on all sorts of actuarial factors, lifespan, things of that nature. The point is, Your Honor, those people who retired before the law took effect contributed everything they needed to for their base pension benefit and their COLA benefit. The monies are in the Division of Pensions and Benefits. If they're not, and the state has misused them, that's misconduct and malfeasance on their part. They can't use trust funds for inappropriate, non-designated reasons, then turn around and ask this court, you know what, we don't have the money, let us impair the contract. What they're really saying is, we took the money and we want the victims of this act to make restitution. All of those monies were paid, Your Honor. I asked the court to pay close attention to how those numbers are in fact computed. Retirees who've left or retired have paid for both their base pension benefit and their COLA. The monies are there, they're subject to federal and state law, they're trust funds. I'm not asking this court to order the state to take money from the state treasury.
I think we
for COLAs.
understand your
Very well. And lastly, Your Honor, although I've already touched upon the equitable arguments, I do want to emphasize to the court they are separate and independent than the contract clause arguments. You might determine maybe there's an impairment analysis and you send it back for a hearing on facts. You need not do that for retirees who retired before the law took effect. Equitable doctrines would permit this court to order the payment of COLAs, even if that other basis has to go down for a rehearing. And I can't urge that strongly enough, because this court has stated for the last 35 to 40 years that equitable principles prevent the state from taking away an individual's pensions, especially once they've retired and they've completed the contract. And as I indicated in my reply brief, extensively I've outlined that law, and it is an independent basis this court can rule upon, notwithstanding the argument regarding the federal and state contract clauses. Any other questions?
I don't. Judge Carroll, do you have any questions for Mr. Ouslander?
No, I do not. Thank you.
All right, very
Thank
good.
you.
The interveners wish to argue next?